Good morning, everyone, and a very warm Yuletide hello from 39 Essex Chambers, where we're presenting a webinar in relation to the new National Planning Policy Framework, which was published last week. This is, we believe, the first Planning Chambers webinar. 39 Essex Chambers are always at the forefront of these things. Today we have a stellar lineup and cast of speakers, colleagues of mine from 39 Essex Chambers, who are going to discuss different aspects of the framework. The first speaker is my great dear friend and colleague, Tom Hill, KC, who's going to be giving a general overview of the changes. The next speaker will be Celina Colquhoun, who's going to be dealing with matters relating to the presumption. Then Victoria Hutton, who will give us a deep dive into the delivery of housing. And finally, James Burton, who will deal with grey and green belt. The webinar is expected to last about an hour. We want to have time for questions, and we encourage you to send in your questions on the Q&A function. And we'll hope to get round to those questions, but from past experience, it won't necessarily be possible to answer all of them, and we'll do our best to respond in writing in due course if we haven't got to your question. I expect, as I say, that this will last about an hour, but it may go over. We're going to be slightly flexible on time. You will expect to receive, if you've signed up for this webinar, the slides which three of the speakers will be presenting. That's Celina, James, and Tora. And so if you miss anything, you'll be able to pick it up in due course when you receive the slides. So with that background, and without further ado, I'm going to turn to my friend Tom Hill to start with a general overview on the changes to the framework. Tom.
Thank you very much, Peter. Can everyone hear me clearly? So it's nearly Christmas, and that can only really mean one thing, another present from MHCLG. And last December, the department gave us what turned out to be Michael Gove's valedictory version of the NPPF, calculated, some would say, to put the brakes on house building in the Tory heartlands. And the year before, in December 2022, just before Christmas, we of course received the consultation version of that document, with a full year passing before the big reveal. And now the MHCLG elves have been working away again, and we have the first NPPF of the new Labour government. Of course, we haven't had to wait as long this time between the consultation draft in July and the published version 5 months later, although some of what's been included was foreshadowed to a greater or lesser degree during the election campaign. And so it has, in reality, had a slightly longer period of exposure to public comment. Well, we're here this morning to consider what it says, what it does not say, and what does it mean. There are, in my view, three overarching themes worthy of mentioning in my introductory comments. And this is intended to be a focused webinar. My role this morning is simply to introduce these themes and offer some high-level personal reflections on how the new NPPF might operate before Celina, Tora, and James provide a more granular analysis. And there were three topics in particular I want to mention. First, as expected, the framework provides adjustments and resets to the range of levers which individually and cumulatively provide the numerical framework for both decision-taking and plan-making in relation to planning applications for housing development. These feed through to the specific parts of the framework directed to decision-taking and to plan-making, as Celina and Tora will explain. Second, the most significant area in which the new government has adjusted and reset long-standing planning policy is in relation to the Greenbelt. And here we see, for the first time really, since its inception 80 years ago, some radical attempts at intervention. It appears with the purpose of prompting the release for development of parts of the Greenbelt, and in particular via the introduction of the Grey Belt concept, which for the first time finds its way into the NPPF glossary, and no doubt will follow into the OED in due course. James will be saying more about this shortly. And the third theme that I picked up really is the absence of new policy designed to facilitate and drive forward the delivery of new housing development within the main urban areas, on brownfield sites and in our town and city centres, where swathes of land formerly in employment or retail use lie underused and yet in locations which are crying out for intensive housing-led sustainable development. So before the more focused analysis by Celina, Tora and James, I'll just say a little more about what the framework may mean or may not mean in each of those three areas. First, in relation to housing numbers, we're looking at the reversal in numerical terms of the policy changes implemented by Michael Gove in the framework of December last year, and more. In particular, as Tora will explain, we have the reworking of the standard method in the accompanying PPG to achieve a different set of outcomes, again reversing the urban uplift as implemented by Michael Gove. And the context for these changes is, of course, the loudly trumpeted goal of 1.5 million new homes to be constructed during this Parliament. However, the underlying structure of housing policy remains the same. Delivery of housing continues to be delegated almost exclusively to the private sector, and the expectation continues to be that the profitability of housing development will be sufficient to induce delivery of housing at the requisite scale and at the requisite pace. The assumption remains that the granting of an increased number of planning permissions will necessarily result in an increased number of completions. Private developers upon whom delivery is dependent will be left to decide what financial risks they're prepared to undertake in a world where construction costs have in recent years been subject to unprecedented levels of inflation, and when the cost of money remains historically very high. There's no indication at present of any broader role for the public sector in the delivery of housing. In terms of the time required to complete major housing development, there is still no real recognition of the difficulty of overcoming the obstacle course, which is part and parcel of the process of obtaining planning permission and then implementing it. And whilst housing needs are intended, as they should, to attract great weight, there remain a large number of very powerful considerations, such as the conservation of habitats and biodiversity, flood risk, the protection and preservation of national landscapes and heritage assets, which require and will continue to require careful assessment and navigation. These simply cannot be ignored, and this means that there are decelerating forces at work which simply cannot, as a matter of law and policy, be circumnavigated to speed up the development process. And it's not clear yet whether expectations have been managed effectively in this regard. Third element of this first theme of housing and housing delivery, the other side of the coin, of course, an authority which has grappled, a local planning authority which has grappled with its housing needs, identified sites to meet those needs, and adopted an up-to-date development plan, will continue to be well placed to retain control of its decision-making and resist unwanted development. Second, there is the revision of Greenbelt policy, which has received so much attention and publicity well beyond the professional planning sector. Of course, the Greenbelt in its totality represents a small fraction of the country, less than 13%, affecting only 16 metropolitan areas in England. Much of the Greenbelt is also covered with multiple other protective designations, such as national landscapes, the former AONBs, and or SACs, which are of course unaffected by the revisions to the framework. The repeated reference to petrol stations, abandoned petrol stations, and garages and car parks does make one wonder whether the newly defined grey belt is really going to be a source of a significant quantum of sustainable housing, quite apart from the small size of some of the exemplars, that the nature of grey-belt islands in the broader spread of the Greenbelt may well mean that in many cases they are not especially well related to the existing urban area, sustainable transport opportunities, services or facilities, and are not in fact appropriate for housing development. What is most evident, however, is that the new policy wording establishes new tests and concepts which will require interpretation and application on a case-by-case basis by decision takers. For example, there will be a need to assess the strength of a notional grey-belt site's contribution to greenbelt purposes. We are told there will be more guidance issued on how to use the grey-belt concept in January next year, but it will only be once those decisions begin to be taken that we will see how much of the additional source of housing supply the Greenbelt will in fact be. Some consultancies have estimated a total capacity of 100,000 to 200,000 units on Greybelt land, but that's unlikely to come forward quickly, and it remains unclear how much of a dent Greybelt sites will make in the 1.5 million new homes target set for this Parliament. Third and last of my three themes, the elephant in the room, one section of the new framework which appears virtually unchanged is Section 7, ensuring the vitality of town centres. And yet across the country, the decline of so many town and city centres is simply unmissable. Not just myriad vacancies in secondary and tertiary areas, but often in primary frontages too. Nearly 200,000 empty retail units, according to recent estimates, accompanied by empty office blocks and retail warehouses in large numbers. Almost by definition, these centres are at the heart of sustainable transport networks, well related to schools, hospitals and other services, and well placed to support and sustain surviving but foundering retail and other town centre uses. However, there's very little so far to suggest that the government is intending to grasp the challenges and opportunities in terms of the potential of town and city centres to deliver a large quantum of new housing sustainably. They are frequently far more complex development opportunities than their greenfield cousins, but their development can, of course, deliver multiple societal advantages and gains. The public sector is needed to convene and drive forward these opportunities with new vigour and new resources. But there's no evidence, at least from the new framework, that this is seen as a top priority for MHCLG. In conclusion, for my overview, there is certainly innovative new policy to be found in the new framework. And there is, of course, a new Secretary of State at the helm in the MHCLG. And it will be very interesting to see how often the Secretary of State intervenes to recover applications and appeals so as to ensure that the Minister is the decision taker as well as the national policy maker. Early indications suggest that this may be quite a frequent occurrence, and certainly those who have made their professional lives in the planning world are going to be very busy over the next few years. So those are my comments by way of introduction and overview, and we'll move on now to the more granular analysis.
Thank you very much, Tom. Again, I must ask, can everybody hear me? Good, thank you. And Tora is very kindly going to be moving on the slides, so I shall say something indicative about that when I come to my next slides. So everybody, what I'm going to concentrate on is the new bits of paragraph 11. They aren't, spoilers alert, they aren't as great a swathe of changes as we might have expected from the consultation, and I'll take you through that. And then I'll concentrate on a particular change, which may give rise to certain legal debates we shall wait to see. And a further issue that I have noted from the way that they have approached changes to paragraph 11. I'm then going to just highlight the approach to plan making, which again, spoilers, that there's not been a great change to, well, there's not been really any change to the paragraph 11 on that, but the way that the transitionals are approached is going to be very important for those who are in the midst of and at various stages of their plan preparation. So thank you very much, Tora. Could we have my first slide, please? So lots of lovely colours. What I've done here, just to remind everybody, is concentrating on the decision-taking part, so paragraph C and D. You will see from the bits that I've highlighted from the older version, the 2023 version, the reference in paragraph D, the great triggering section, that the approach adopted was where there are no relevant development plan policies which are most important for determining the application, those are to be treated as out of date, and permission should be granted unless we have the two limbs of D1 and 2. The highlight that I made in D Roman 1 is of particular note because that limb requires that the application of policies in the frameworks which are in the footnote provides a clear reason for refusing the development proposed, and then little Roman 2, any adverse impact, etc., which would significantly demonstrably outweigh the benefits in the framework taken as a whole. So those are the highlights from that. When we came to the consultation version, there was an interesting approach that seemed to want to take us back to those debates we had back when we had paragraph 14 to debate about what was meant by the meaning of supply of policies for the supply of housing. So what was reintroduced or effectively introduced was a change to policies which are the most important for determining to policies for the supply of land which are most important, and there was a definition of that. That seemed to highlight for us all, this is just going to be about housing. Now, there were clearly a number of points to debate about that and a number of responses to made to that sort of approach. The other thing was, however, that little Roman 1, the limb 1, remained the same. It referred to the application of policies in this framework, protecting areas of assets of particular importance, providing a clear reason for refusing. In respect of little Roman 2, there were changes to not just the approach to policies as a whole, but it emphasised in particular those for the policies and design of development, and in particular securing affordable homes. So the approach from the consultation version was let's concentrate on those policies for the supply of housing being the trigger, and secondly to broaden out or to emphasise that in limb 2 that you needed to look in particular at specific policies. So, sorry, second slide, please, Tora, thank you. So, more colours. The blue, which I've sought to highlight, is the new stuff. And yellow is from the previous version. So what we've got for paragraph C and D, C is the same, but D brings back the old wording where there are no relevant development plans, policies, or the policies which are most important for determining. So back to our original knitting. For little Roman 1, however, we have some new wording, albeit it reflects wording elsewhere within para 11, which relates to plan making, which refers not to clear reasons, but to strong reasons. And that is the wording that has now been inserted. So just to be clear, what we have now under little Roman 1 is the application of policies in this framework that protect areas or assets of particular importance, which are in the footnote, providing a strong reason for refusing development proposed. And I'll come in, have a little discussion about strong reason versus clear reason, but that is the first big highlight. Secondly, with regard to limb 2, We have the same framework policies taken as a whole, but slightly different wording from the consultation version. It says having particular regard to key policies for directing development to sustainable locations, making effective use of land, and securing well-designed places and affordable. So it's widened it out. And again, I'll come on to what the implications of that might be. So next slide, please, Tora. Thank you. So we're looking firstly at the footnotes, changes to the footnotes. Footnote 8, which has now been changed, this refers to whether, well, you know, when we're looking at the policies which are most important for determining the application are out of date. And this includes applications involving the provision of housing situations where the local planning authority cannot demonstrate the 5-year housing land supply, or where the housing delivery test indicates that the delivery of housing was substantially below less than 75% housing requirement. Now, I'm not going to go into the implications of that in terms of the test, but because Tora is going to be looking at housing delivery. But you'll note from that, that is the new wording for footnote 8. In terms of the 2023 version, we can see that what was proposed was a different approach in terms of 5-year housing land supply with a buffer, and indeed where the housing delivery test indicated a delivery below 75% of the housing required over 3 years. So again, we've got that test there. Now, the consultation version, this actually was related back to that new approach in terms of policies for the supply of land. So that indicated that policies for the supply of land are those which set an overall requirement and or make allocations and windfalls. So don't get confused. The consultation version of footnote 8 was actually directed at that first limb. Let's turn then to my next slide, which looks at what the footnote 7 actually says. This is unchanged from the 2023 version, other than references to different paragraphs. But what I wanted to make clear of here is to just emphasize that this is in relation to the strong reason, not clear reason. So unchanged, but let's see what happens with this strong versus clear reason. Next slide, please, Tora. So what we have in relation to key policies for directing development to sustainable locations, the consultation version, which I've highlighted in green, referred to a series of applications involving housing situations where can't demonstrate 5-year housing land supply, etc. I'm going to just highlight those because time is quickening. But if you could go to the next slide, Tora. The issues that I wanted to highlight firstly are, what is the approach that should be adopted when you've got different versions of the NPPF? We've got clear guidance from Paul Newman, which says it's not helpful to consider the language of earlier NPPFs when which are deliberately and materially different. So that is the first point. Secondly, Redhill told us that where the government intends to make a significant change, it would be expected to make a clear statement to that effect. So keep that in mind. With regard to clear versus strong, Monk Hill looked at what provides a clear reason meant and gave very good guidance upon what that meant in terms of clear reason. Now, it may be said that a strong reason versus clear reason is just noodly legalese and that there shouldn't be any difference between it. But in my view, there is a deliberate choice to use a different word, to use strong, not clear, and that there may be debates about whether that there is there is a more effective and noodly process that's required in order to decide whether there's a strong reason amongst those policies that render the trigger applied or not. So I'm just going to quickly rush through to my other slides. Tora, thank you. If we could, thank you. So in terms of policies and framework taken as a whole, we've got guidance there, which I've referred to in Gladman. I think that having particular regard doesn't really alter things too greatly. But again, I've just highlighted what we need to look to in terms of applying that. And then Tora, if we could just move on. So what I've set out there are the changes, and there's a whole series that I've highlighted through the rest of my slides. The main thing to concentrate on is that the duty to cooperate is still there, but there are a lot more requirements on local authorities post that initial agreement under a duty to cooperate to keep that duty applied. And that inspectors will be expecting to see how that is consistently being applied throughout the process. And then lastly, sorry, if we could go to the last series of slides, forgive me, it's the transitionals, as I've called them. If you could go to, yes, Annex 1. So the principal date to keep your mind upon for the transitionals for plans is that from the 12th of March 2025, to the purpose of plan making, the NPPF applies. And I've set out there all the little differences in the footnotes. I'm going to leave it there because time is ticking. But if there are any questions, of course, we can get back to that. But hopefully when you receive those slides, they'll be helpful. Thank you very much.
Celina, thank you very much. We're getting a number of questions through, so we're going to be giving these as an overview and hopefully get into some of the detail in the Q&As. But I'm going to focus on housing and the new NPPF. And the particular documents that I've been looking at are Chapter 5 of the new NPPF, a couple of revised PPG chapters, so Housing and Economic Needs Assessment, Housing Supply and Delivery. We're looking at the government's response to the consultation, the ministerial statement of Matthew Pennycook made last Thursday, the outcome of the new standard method, so the numbers, and then the housing delivery test measurement rulebook. And the key messaging coming out of government is this 1.5 million homes and the commitment to radically boost the supply of housing. But one quote that really stuck out to me from the consultation response is the last one on that slide, and that's the imperative of rapidly driving up planning consents in the context of a system with inadequate local plan coverage will increase the number of permissions secured outside of plan allocations. So we're in a plan-led system, but the reality is we're going to see a number of consents given outside of the local plan process. So thoughts and prayers with pins, I think, at this point, because I think we can see a lot of this coming to appeals in the near future. So what are the key changes to the policy? Well, we've got a new standard method formula, and I'm going to go into that in a bit more detail in a minute. We've got the standard method no longer being an advisory starting point, although I think that is nuanced. And so, again, I'm going to come on to that in a bit more detail. The 4-year supply protection for some plans is gone. So it's 5-year supply or bust. We've got, of course, apart from the neighbourhood plans policies, which are unchanged, we've got the removal of protection, which some recently adopted local plans enjoyed. So you remember there was a sort of 5-year grace period for local plans. That's gone. The urban uplift has gone, which I think Tom mentioned earlier. We've got 5% and 20% buffers are back, and I'll come on to those in a bit more detail. And then we've got a focus in the affordable housing space, particularly on social rent. Again, I'm going to go into that a bit more detail as well. So starting with the standard method, now it used to be that the baseline for the standard method was set with housing projections. But that has now changed, and it's housing stock which is going to be used as the baseline, or is used as the baseline, and it takes 0.8% of an existing stock in a local authority area. That is then adjusted for affordability. That multiplier has been amended, but I'm not going to go into that far too early on a Monday morning, but it's there for those who want to have a look at it. One thing to note is it doesn't include a rent-related adjustment. That was posited in the consultation document, but the government have said actually the evidence behind that is not sufficiently robust. So, and as I said earlier, the standard method is not now the advisory starting point. The NPPF text itself says it should be used, but if one looks at the PPG, we can see that it says it should be used to address housing needs. However, it's recognised there are some specific circumstances in which an alternative approach could be justified. For example, as explained in paragraph 14. And what's in paragraph 14 is acknowledgement that there may be some areas where the strategic policy-making authority boundaries don't match the local authority boundaries for which the standard method figures have been arrived at. But I just note that for example, because I think that will give there may be some local authorities coming forward saying, well, here's another example of why we shouldn't be using the standard method. And we can see some arguments over that at local plan examinations in the future. So what are the results? Well, the short summary is that everywhere has increased, save for London over the old standard method, but the London figures are still well over and above that which is provided for in the London plan. So a very significant challenge, unsurprising given this 1.5 million figure or target set by the government over their parliament. Going to have a look at buffers briefly. So this is paragraph 78. And if you see the last sentence under the first bullet point there, the supply of specific deliverable sites should in addition include a buffer moved forward from later in the plan period. And the standard buffer is 5%. That's to ensure choice and competition. 20% where there's been significant under-delivery of housing over the previous 3 years to improve the prospect of achieving the planned supply. That's measured against the housing delivery test. And this is the very interesting buffer, which is para 78C. And just before going on to explain what it says, the government's recognised that there will be, so we've got these local plan transitional provisions, which will effectively allow some, well, very probably very many local plans to continue to be adopted under the old versions of the NPPF, or indeed there'll be ones that were adopted this year, last year, etc., and whose 5-year housing land supply will be assessed against the figure in the plan. And the government's realised that there's probably going to be a very significant mismatch between the plan figure under an old NPPF and what is now required under the new standard method. And so in order to try and address that, the government has introduced this additional buffer in 78C, and that adds an extra 20% where the local planning authority's housing requirement was adopted in the last 5 years against a previous version of the framework, and where that requirement is 80% or less than the most up-to-date local housing need figure. So, and that would come in from the 1st of July 2026. So I'm sure there'll be a number of plans fitting into that additional buffer. Just briefly on affordable housing, unsurprisingly, this has been a concern of this particular government. Note paragraph 63 requires an assessment of need for different groups in society. We've always had that in the NPPF, but we now have that particularly highlighting social rent as part of affordable housing, and also looked after children is one of the requirements for assessment of need. There's then at paragraph 66 a specific requirement that affordable housing should meet identified local needs across social rent and other affordable housing for rent and affordable home ownership tenures. So that's to try and move the development industry away from providing that which is most profitable to that which effectively meets the needs of the area. And then finally in Greenbelt, there's an expectation that there would be a 50% affordable housing requirement, or in any event, and greater than that which would apply to non-Greenbelt land. Very briefly, what about the economy? Well, just to highlight there have been some changes to 84B and 85, essentially supporting particular needs of the modern economy. So laboratories, gigafactories, data centers, digital infrastructure, etc. So just to be aware of those changes. And then finally, I think I just wanted to highlight an announcement that came out yesterday on a Sunday. And this is the government's planning reform working paper, Development and Nature Recovery. And it's effectively a consultation document, but the proposal is for more strategic solutions from the government to deal with environmental concerns, particularly under the habitats regulations. So nutrient neutrality is one of the particular roadblocks mentioned in that paper, but it's also proposed to go wider, and it seems to be a sort of modular approach whereby a developer would pay into a strategic fund to deal with a particular environmental issue, and government would be tasked with providing the solution. So that may be one piece of the puzzle addressing the obstacle course that Tom was talking about earlier. But I think what this is a reminder, as Tom was saying, that actually there is still a considerable obstacle course, whether it's habitats, heritage assets, national landscapes, etc., providing potential blocks to development. And it may be that expectation management hasn't been done by this government. So we'll see how it all fits together in the end, but it seems that there's going to be lots more to come. And with that, I'll pass over to James to go through the Greenbelt changes.
Brilliant. Thank you so much, Tora. For speed, Tora, could you keep sharing the slides? Thanks ever so much. So I'm James Burton. I'm going to talk at some speed about the Greenbelt / Grey Belt, and let's see to what extent Greenbelt landowners have had an early Christmas. Next slide, please, Tora. So we have some significant changes, no question. They are led by this entirely new concept of Grey Belt and the contributions golden rules for major housing development releases and permissions. But it's not all about that, because PDL, development on PDL, also gets a boost, whether or not it's Grey Belt, and we need to remember that that's in the context of a greater emphasis, even greater emphasis, on brownfield redevelopment. And the changes affect both plan making and decision taking. There are various definitions that are right up for grabs, certainly open to a range of response in their application. And we're promised quite a lot of guidance, it seems, in early 2025. So this is only, as Tom said, this is only part of the parcel. It's a multi-layered, wrapped thing. I will go through at a lick. Let's start with plan making. Next slide, please, Tora. And let's just remind ourselves what hasn't changed. So the fundamental aim of Greenbelt policy to prevent urban sprawl by keeping land permanently open, that has not changed. The Greenbelt purposes have not changed. And they're really important, of course, when we come on to identify Grey Belt. The policy regarding new bits of Greenbelt is just as restrictive as the old. Will contrast with a relaxation regarding alteration of Greenbelt boundaries to certainly release Greenbelt land, but you have still got to demonstrate as an authority that you've fully examined all other reasonable options for meeting identified need for development before concluding that exceptional circumstances exist to alter those boundaries. The other 3 bullet points we can pass over. Next slide, please, Tora. Thank you. So, an outline of the changes as concerns plan making. Well, the first thing we've got in order of appearance, as it were, is a reversal of what I always read as essentially a discouragement of greenbelt boundary review when you were plan making or reviewing your plans. Quite the contrary, what we've got now is a heady combination of removal of that discouragement, or the reminder that you know, back in the old version, you didn't always have to review greenbelt when you were plan making or reviewing a plan. And now we've got these specific examples of exceptional circumstances, which are pretty broad, as you can see from the slide. If an authority can't meet its identified need for homes, commercial or other development through other means, and brackets to myself and all, well, that essentially means all development, if there's an identified need for it, doesn't it? And provides that in that event, you have got to review your greenbelt boundaries and propose alterations to meet those needs in full, unless doing so would, quote, fundamentally undermine the purposes taken together of the remaining greenbelt across the plan area. Now, we are promised guidance about that bundle. Then, when greenbelt release is necessary, we have a new priority order and a new concept within it. The priority order is PDL first, then grey belt that isn't PDL, and then other green belt, albeit that's all run through with the need to promote sustainable patterns of development and ensure determine whether such location is appropriate, with a reference back to paragraphs 1110 and 1115. Now, the new 156, para 156 contribution golden rules should apply to greenbelt release for development. I'll come to that in a little more detail. Next slide, please, Tora. Couple of points of detail or application. So that change from old para 145, the old, as it were, discouragement as regards to greenbelt review, to new 145, 146, means an authority will have to A, review greenbelt, and B, release it to meet identified need, provided it's demonstrably the case, examined all other reasonable options for meeting the need, and unless, as I say, doing so would fundamentally undermine the purposes taken together of the remaining greenbelt across the plan area. It's inconceivable to me this will not lead to greenbelt release nationwide, especially given the implications of the new standard method for unmet housing need that Tora has just explained. The second point, I think of some interest, is that where greenbelt land is released for development through plan preparation or review. Now, the wording of this part of the PMPPF says the contributions golden rules at 156 should apply. It might give rise to an argument on interpretation. Do they apply if greenbelt land isn't released for major housing development? Well, it might. I can't see it. We'll come on to 156. It seems to be pretty clear that they only apply in relation to major housing development. Next slide, please, Tora. Decision taking. What has not changed in outline? Well, the general approach to inappropriate development and very special circumstances, but with an important carve out for not inappropriate previously developed land or grey belt development. The definition of very special circumstances hasn't changed, and the old familiar harm must be clearly outweighed test. Lots of the old sub-paragraphs of what is not inappropriate development are still the same, but we do have, they're bundled up in a single paragraph now, but we do have an important, I think, important change regarding previously developed land. And of course, we already have the policy regarding renewable energy products have been altered, and that stayed the same. Next slide, please, Tora. So a couple of further points. We've got, for previously developed land, a boost here, a real boost, it seems to me, because no longer do you need to meet an identified need for affordable housing in order to engage the test of not cause substantial harm, which of course is a very narrow, relatively speaking, circumstance to show that's not inappropriate development. Now we have this new paragraph which applies across the board and doesn't have that particular limitation to it. We've got an important change to the definition of PDL in the annex. And the big point there is that large areas of hard standing are now brought in, but as the consultation response explains, not expressly glass houses. And we have this brand new type of not inappropriate development on grey belt, which is clearly broader than the PDL not inappropriate development, which if it's major development for housing is subject to the golden rules. Next slide, please, Tora. So compare old para 152 and 153 first sentence with the new 153 first half and footnote. There is, I'll let the words speak for themselves, but there is clearly an incentive for not inappropriate previously developed or land or grey belt development, because even if it causes green belt harm, there's no direction to give that substantial weight. Next slide, please, Tora. Second, when is grey belt development not inappropriate? Well, it's not inappropriate where, and the first thing is, again, it does seem to include essentially all development in the wording, homes, commercial and other development. That would not be inappropriate in the green belt where A, it would utilise grey belt land and would not fundamentally undermine the purposes taken together with the remaining green belt across the plan area. B, there's a demonstrable unmet need for the type of development proposed. C, it would be in a sustainable location, again, with particular reference to those Turner 115 paragraphs, and D, where applicable, it meets those contributions golden rules. I won't read footnote 56, but it tells us what demonstrable unmet need means for housing and traveller applications. Next slide, please, Tora. What is grey belt? Well, here we have the definition, and bear in mind this has changed somewhat from the consultation. Essentially, do not believe you can rely on what the consultation draft was for any of this. So grey belt is defined as land in the green belt comprising previously developed land or any other land that in either case does not strongly contribute to any of the purposes A, B or D. It excludes land where the application of the policies relating to the areas or assets in footnote 7 other than green belt would provide a strong reason for refusing or restricting development. So we could have some PDL plus some other land or simply other land, so long as it doesn't make that strong contribution to A, B or D, and there's no strong green belt reason for refusing or restricting under footnote 7. Question, does either case allow some salami slicing? I think that's doubtful, but it might be arguable. But again, we're promised guidance early in the new year. Remind yourself at the bottom of the slide, and all these slides will go out after the seminar, of what those A, B, D purposes are. Next slide, please, Tora. So what are the golden rules? Well, when do they apply? Well, they're subject to transitional provisions. They apply where major development involving the provision of housing is proposed on land released from Greenbelt through plan preparation reviews or on site. Greenbelt sites made subject to planning applications. By the way, involving the provision of housing clearly means you do not have to have a housing exclusive development. Mixed development will be caught, but it has got to have that housing development, certainly in my view. In that event, these following contributions should be made, and you've got an affordable housing contribution, a local national infrastructure contribution, and then a green spaces contribution. And I won't read all the text. Question, do they apply only to grey belt? Well, not on the policy wording. Next slide, please, Tora. And I've set out a chunk of text regarding the affordable housing requirement. I'm not going to go into the detail of that. You can read all of that. Do note that there is an intention, we are told, to review the viability guidance as to whether there are circumstances in which site-specific viability assessment may be taken into account, e.g. PDL. Next slide, please, Tora. As regards the green space requirement, just remind yourselves there is more about nature recovery than the draft consultation text. Anyway, if you can jump through those hoops, then you get a boost. You get significant weight in your favour. Transitional provisions for the golden rules. Well, there are transitionals, such as they're not particularly extensive, but they are there. They don't apply to development brought forward on land already released from the Greenbelt by plan making or granted plan permission prior to the publication of the framework. The effect of footnote 59, in my view anyway, is to exclude variations to existing permissions that were not subject to the golden rules. Does that mean section 968 and section 73 and the new 73B? Question. Next slide, please, Tora. So final thoughts from me. We're told by the government's consultation response that guidance on Greenbelt review, including identification of grey belts, should be with us in January 2025. Can we hope for a clear steer regarding such as strongly contribute to Greenbelt purposes A, B, or D? Will local policies for affordable housing throw up material variations, plan area to plan area, as to whether the golden rules can be met? And note this rather intriguing bit in the consultation response in discussion regarding whether the government should set indicative benchmark land values for Greenbelt release or development, which it still says it believes has some merit, but it needs to do further work. And you have that in response to question 39 that it wants to restrict access to viability assessment, ensure the viability system is not used to subvert government policy intent. The government will update planning practice viability guidance prior to new viability guidance being published. Site-specific viability assessment should not be used. Hard to know what to make of that, really, coming as it does, but there it is. It provides a clear steer. Okay, thank you. Richard Howard has asked me what's happened. So I shouldn't have. Richard Howard in Chambers, so I'm allowed to say his name, is asking me what's happened to my Santa hat, and the answer is, Richard, it's coming on now for the Q&A. So there you go.
Right, thank you very much indeed, James. I think probably unsurprisingly, most of the questions are directed to Greenbelt, and I mean, we have time just to get one or two of these in. James, I'm going to ask you to deal with a question which
see the question
is quite a long, lengthy question. I'll read it out. Application submitted for an integrated retirement community on Greenbelt. Site clearly meets definition of grey belt, however cannot meet one of the golden rules in that 50% affordable or 15% above policy cannot viably be provided on site. Would the development therefore be classed as inappropriate development as previously, as clause D in paragraph 155 is not satisfied? This will be a problem for all operators bringing forward IRCs. All, even on Greenbelt, have viability cases that accompany them. Revised PPG makes clear you can't do this on grey Greenbelt, but this is going to be reviewed at some point in 2025. If you don't hit the golden rules, is grey belt pointless and you remain inappropriate development, and very special circumstances will still be needed?
What a question. Well, I think the short answer to the question is, I'm afraid, yes, you are still inappropriate, because 155 is a got to hit them all or you don't get through the door. That is a very standard bit of drafting, and it's telling us that this is an aggregated set of sub-paragraphs you have to satisfy across the board. So you've got to utilise grey belt land and not fundamentally undermine those purposes taken together of the remaining green belt across the area of the plan. You've got to show that demonstrable unmet need for the type of development proposed. You've got to be in a sustainable location, ref paras 1110 and 115. And unless you can somehow tell me that you're not major housing development, which I suppose is your only potential wiggle, but I think we have to assume that you probably are based on the description, then you've got to meet the golden rules.
The golden rules set out in 156 to 157.
Yeah.
And 156, of course, sets out the golden rules, which are affordable housing which reflects either Roman I development plan policies produced in accordance with Paris 67 to 68 of this framework, or 2, until such policies are in place, the policy set out in para 157 below. So that golden rule incorporates 157 below.
Yeah.
And 157 below says before development plan policies for affordable housing are updated in line with 67 to 68 of this framework, the affordable housing contribution required to satisfy the golden rules is 15 percentage points above the highest existing affordable housing requirement, which would otherwise apply to the development, subject to a cap of 50%. In the absence of a pre-existing requirement for affordable housing, a 50% affordable housing contribution should apply by default. And then it says the use of site-specific viability assessment for land within or released from the Greenbelt should be subject to the approach set out in National Planning Policy Guidance on Viability. So to my mind, that would incorporate an opportunity to bring in viability testing to get within the golden rules. Am I wrong about that?
You're not wrong, Peter, but that's why I flagged that, I think, rather important consultation response regarding site-specific viability testing, because it looks as if what's going to come in January is actually going to make it extremely difficult to rely on site-specific viability testing. That seems to be the intention.
Okay, well, it's a very good question, I have to say. I mean, you've heard what both James and I have had to say about that. I think, I mean, certainly my advice to you would be undoubtedly to frame your application on the basis that it does comply with the golden rules, and in particular, but subject to the viability testing. I mean, let's face it, affordable housing can only be provided if it can viably be provided. And so you will have to ensure that your clients produce a full viability, I mean, I'm sure they already have actually, produced a viability assessment to deal with that. But thank you very much for that question. As has been indicated, I'm not able to say who asked the questions for some obscure reason.
Yeah, we can only name people in chambers for data protection reasons.
There we are. Yeah, we have then the sensible question from our esteemed colleague Richard Harwood KC as to why are you wearing that ridiculous hat?
No, he wanted me to wear the hat. He's worried I wasn't wearing it. Yeah.
Okay. Right, now any other questions? Well, I warned that they were going to be mainly Greenbelt, but I think there was one for which Celina might wish to.
Tora had one as well, actually.
Oh yes, okay. Well, let me deal with Celina.
Yeah.
Can Celina explain the implications of footnote 9 and how individually or in combination be interpreted?
So that's a reference to the end of the new bit to para 11D2.
Right. That's footnote 9 at the end. Yeah.
So that refers to, in particular, the series of policies, and then individually or combined. I think, given that there's that tension between looking at the framework as a whole and then this new bit about in particular, what that's being directed at is a sort of local plan approach. So where one policy within the framework pulls in one direction and these particular policies might pull in another, then what it's implying is that a particular level of weight might be given to those policies. But you can't simply render a policy that might be irrelevant just because it's not highlighted, because you've got to look at the framework as a whole. So they're not that, the words aren't that helpful, but the implication that I've taken from that is that there is the capacity for a policy that's highlighted within that last section and in footnote 9 to individually or with those other policies to pull a little bit further perhaps than a policy that pulls in the other. But that is the best I don't think very helpful wording.
Thank you very much indeed. And finally, in terms of timing, we're just about to wrap up. So this is the very last question we're going to have time to answer. Recent ministerial statements, the question is recent ministerial statements and press reports that the government might allow ecology restrictions to be given less weight to the need for new housing does not seem to be reflected in the new framework. Would that be your view too? And Tora, I think you've touched on this already, but would you like to say anything further?
Yeah, thank you for that, Peter. I think that's right. I don't think that the NPPF has made that. I mean, if those promises were made, that hasn't come through in this NPPF. We've got this working paper delivered yesterday, which I think it's my reading of the government's position is not about giving less weight to ecology and biodiversity, but rather trying to find the solutions through the obstacle course that Tom was talking about. And, you know, that's unsurprising. We're signed up to very many conventions dealing with ecology and biodiversity, and actually the wiggle room for throwing things out the window or riding roughshod over these things is pretty small. So I think it's going to be a solutions-based approach as opposed to simply just allowing it all to be outweighed by housing delivery.
Okay, well, that I think, and unfortunately brings us to the end of the webinar. First of all, I'd like to thank you all for logging in, for perhaps a record attendance of over 500 people this morning, drinking their coffee and eating their bacon sandwiches with us. And I'd also like to thank on your behalf the speakers today who at short notice have dealt with very expertly the new issues that have been raised. We're really delighted with the support you give 39 Essex Chambers, and we are very much hopeful that you'll be able to ring any of us individually or ring up Chambers and Clerks if you want any further assistance on the interpretation of any of these matters in due course. With that said, all it remains me to do is to wish you all a very happy Christmas. From 39 Essex Chambers, thank you and goodbye.
Happy Christmas.